Welcome back to the video series, Making International Law in Korea. In this week, I'm going to explain to you about intertemporal law and the territorial dispute in Asia. Intertemporal raise questions about what legal rules to apply to particular disputes at particular times. The claims of parties to dispute territory must therefore be evaluated using the international law and the prevailing legal standard in existence at the critical date when the disputes are and the issue must be discussed within the context of the critical date. The questions that must be explored within the context of the critical date include the first, whether at that material time, legal concept or legal regime on territorial acquisition exists in Asia. Also, second, more importantly, assuming that such a regime exists, what role, if any, should it play in the resolution of dispute in question? And third, and if such a regime exists, what impact do subsequent factual and legal development have, especially if the area in question have been subject to significant factual and legal changes over the years? Again, this will not attempt to determine which country have a strong claim to the dispute, but rather will focus on the legal implications of the territorial boundary dispute in Asia at the material times. It is debatable whether Asian history shows an essential difference between Asian legal concept and the principles of the general international law regarding modes of acquiring or losing territory. Two possible interpretations exist. On the one hand, one study of the Chinese practice of acquiring losing state territory has pointed out that, for example, close study of the record of imperial Chinese foreign relations does not support the thesis that China in the past always dictated the terms of its relations with other states, as suggested by the traditional tributary system. Rather, this record reveals a complex mixture of the rules and practices, some reflecting the hierarchical presuppositions of the tribute model, others representing ad hoc working compromises between China and other countries. Yet another category of rules and practices appear to have been grounded in shared notion of fairness, equality, reciprocity, and mutual respect for territorial sovereignty. Indeed, Qing boundary rules and cases spanning more than 100 years indicate that substantive equality and reciprocity, coupled with a genocentric hierarchy in form, were the dominant characteristic of the border control system, at least with regard to Qing relations with Korea, Vietnam, Siam, and Burma. On the other hand, from the Chinese perspective, the Western practice of putting everything black and white is not all important. Based on the long history of Chinese administrative geography, the Chinese had their own way to demarcate legitimate political space and marine space in the East China Sea. In particular, the Chinese created the world order by networking their investiture and tributary system to demonstrate the Chinese way of hegemony during traditional period. For the Chinese, history, geography, and actual circumstances have combined to make their ownership of certain territories a reality. Thus, they had frequented these territories uninterrupted and unchallenged by other countries for centuries. Prior to the 18th century, a discovery alone sufficed to entitle states to establish and maintain a sovereignty over the specific territories and the rules of international law. According to the principles of intertemporal law, the evaluation and determination of historic title must be made in light of the rules of international law, which were in force at the time such title was allegedly acquired. It is also debatable, however, whether claims of sovereignty in Asia can be judged by the norms developed in Europe, particularly since the general understanding of how to establish a valid claim to territory has been established through decisions and award by the international judicial and arbitral bodies many centuries later, mainly in early 20th century. Accordingly, evaluating Asian countries' claim of sovereignty over specific territory and boundary disputes would depend, as pointed out earlier, on whether legal concepts or legal regimes on territorial acquisition exist at the time in Asia, and the implications of such concepts and regimes for the resolution of disputes over the specific territorial and boundary dispute in contemporary times. Let me touch upon the authority and legal basis for territorial disposition. There is no uniform rule in international law defining any single manner for cession of territory. Territorial disposition are generally matters of considerable importance to the various nations concerned, and most nations would doubtless desire that the disposing documents be of substantial dignity, named a treaty. Because territorial questions are often threat to peaceful international relations, methods that result in an unequivocal settlement are desirable. For these reasons, the cession by a peace treaty is a common manner of disposing territories of a defeated state. Power disposition, limited or unlimited depending on circumstances, however, is often given by the defeated state in a treaty without naming the recipient. In those cases in which this method has been used, two circumstances are generally present. The first, the disposition is not agreed to by all concerned in a peace conference, and second, some action must be taken outside the peace conference before definitively disposition can be agreed by those concerned, such as a prescriptive, on the establishment of the mandate through international organizations such as the League of Nations. Ian Brownie, the famous international lawyer in his generation, has explained that on a number of occasions, a group of leading powers, perhaps in association with a large number of other states, have assumed the power of disposition, although the legal basis of such a power were problematical. Under the subheading Disposition by Joint Decision of the Principal Powers, he mentions, after defeat of the Central Powers in the First World War and the Axis powers in the Second World War, the leading victor state assumed the power of disposition to be exercised jointly over the territory of the defeated state. State losing territory as a consequence of the disposition in this wise might, and often did, renounce title by the provisions of peace treaty to the area concerned, but the dispositions were assumed to be valid irrespective of such renunciation, and the recipients were usually in possession prior to the coming into force of a peace treaty. The existence of this power of disposition or assignment is recognized by the jurists, but they find it difficult to suggest or to agree upon a satisfactory legal basis for it. Some translate the political realities into legal forms by supporting that the community of states has delegated such a power to the principal or great powers. Where renunciation confers a power disposition to another state or group of states, legal weight given to such right of disposal. With regard to the power of disposition over renounced territory, it has not been the practice of states to give due consideration to the historical interest of the state that has been dispossessed of the subject territory. According to law of succession, when by cession or otherwise, a part of the state territory is transferred to another, a cession to certain right and obligation associated with the transferred territory occurs. Therefore, it seems that the successor state's right to title, whether such title was acquired directly from renunciation or indirectly through disposition, shall be equal to that of relinquished state and shall continue to prevail over other rights in its territory. There may also be circumstances where state relinquishes territory without expressing its intention as to who is to have title to or power to dispose of the territory. The question then is whether the sovereign title of territory should automatically vest in a state that maintains the vested sovereign claim, or whether the territory should be disposed of by collective powers. If the territory is to be disposed of by collective dispositive powers, it seems equitable that those powers give adequate consideration to any existing claim held by a previously dispossessed state.